time to be with us this particular morning.
It's a pleasure.
Now, even as we embrace this conversation, do tell us who's Maureen Kubai?
Okay. Maureen Kubai is a young lawyer, a young advocate who is in data protection compliance, and I am working under Mutier Advocates, which is based in Westlands, and we are a data protection compliance firm. Yes, that is Maureen Kubai.
All right. Now, speaking about data protection compliance, for someone hearing data protection rights for the first time, what exactly is data protection law?
When we talk about data protection law, we are actually talking about the law that safeguards personal information. So when you hear personal information, that is the law that actually safeguards it. So when you're talking about personal information, you're talking about your name, your ID, just your personal information, any information that you think about yourself, whether it's your contact number, your KRA PIN, all that personal information actually should be safeguarded by everyone handling it. All
right. Now, for instance, I know for these times we have technology, and in some cases churches live stream their services. Now, often they often capture congregants on camera. Now, are they required to seek consent to their congregants?
Okay, so that has been a controversial topic that has been going on online, and actually in Kenya and the world in general. So the church, it is not actually only the church. It is every entity that is handling personal data. So what this means is you have to inform the congregants that you're actually collecting their personal data first. And then after you inform them, you have to obtain their consent for collecting that data. For that live streaming, you have to collect that data. And we're not collecting this data and asking them, do you accept for us to take your data? And then they nod their heads. No, we are not doing that. We are actually using explicit and written consent so that we can have proof that actually this congregant allowed us to process their personal data.
And in some jurisdiction, courts have cameras.
Courts?
Not really courts, but the media come to capture the proceedings. Is the suspect or the persons attending the court proceedings, are they do the courts really seek their consent to live stream the court proceedings?
Okay, so when it comes to consent, there are instances whereby it is not a must for us to obtain your consent for that. For example, I want to secure this building against burglary. I will put CCTV so that anyone who comes in, I can collect their images. I won't need your consent. I actually have a lawful basis. We call them the lawful basis for collecting personal data. So when it comes to court, the lawful basis that they are using to collect that data is actually public interest. And it is usually cases that are very controversial in the country. That's why we collect this data, because we want this information relayed to the public. So it is in the public interest for the public to know what is going on in these cases. So the courts, I'd say, they have the right to collect this data without the consent of the defendants, of the plaintiffs, of everyone involved.
All right. Now, there are key data protection laws in Kenya that govern the handling of personal data. Can you provide the overview of the Data Protection Act?
Okay. So the Data Protection Act didn't actually come from nowhere. It has a basis from the Constitution of Kenya 2010 under Article 31, which provides for the right of privacy. And when we talk about Article 31, this is the queen mother of Data Protection Act. This is where the Act came in, And the country saw it fit, because now we are going to the digital world and we are having this personal data being misused. The country found it fit to have this act so that we can at least govern how this personal data is being collected. So in 2010 we had the Constitution, and then it is up to 2019 where we had this Data Protection Act that came into force. This Data Protection Act, it has many provisions, which include establishing the office of the Data Protection Commissioner. The Data Protection Commissioner is actually like the judge. They are the judge, they are the investigators, they are the police. That office has all those mandates. Also, the Act establishes the rights. It also establishes the duties of entities which are processing personal data. It also provides for the principles of data protection. And under Data Protection Act, we have the Data Protection General Regulations, which came in force in 2021. So the general regulations, they are actually birthed by Data Protection Act. The Data Protection Act is not majorly detailed, but when we have these general regulations, they come in to give more details to what the Act is saying. So I can say the Constitution is the Queen Mother, and then we have the Data Protection Act, and then we have the other babies, which are the Data Protection General Regulations. We also have another regulation, which is called the Data Protection Registration of Data Controllers and Data Processors Regulation. This is a regulation that requires all data controllers and processors to be registered with the Office of the Data Protection Commissioner. We also have another one which handles complaints. It guides people or individuals. We call them data subjects when you're in data protection language. So it guides the individuals on how they can file for complaints in the ODPC's office.
All right, and what rights do individuals have regarding their personal data under the Kenyan law, and how can they exercise their, these rights?
Okay, we have a couple. Actually, there are many. There are many rights, but I'd like to talk about a few. So the main ones, we have the right to be informed. The earlier question that you asked me on the chat, whether it has it has a mandate to obtain consent, and I told you, you have to inform the congregants that first you're collecting their personal data. So when you're talking about this right to information, that is when we have privacy policies coming in. And these privacy policies, they actually inform the data subjects that their personal data is being collected and for what purpose and where their data will be shared. So if I come at the gate, I have the right to be informed why they are collecting my ID, why they are collecting my phone number. I have that right. Another right is the right to access to information. So when you're talking about right to access to information, this relates to entities that have already collected your personal data. So for example, I have applied for a job in an entity, and I want you to give me the background research report that you have against me, and I request access to that information. You do not have the right to deny me access to that information. That is because as a data subject, I have the right to access. Another right I can say is the right to restriction of personal data. This relates to whereby you have collected my image and you're going to use it in the church, right? Yeah. Then you want to use that data, my image, to advertise the church. I have the right to restrict you from using that data for marketing, but you can use it in the church. When another right you can talk about is the right to objection. I don't know whether you've ever seen marketing messages that come to you, maybe like a supermarket. It is sending you a list of the products they have on offer. And then down there they have SMS star, is it star 456 star to stop. Yes, now that is giving you a right to object to receiving this messaging, these promotional messages. There are many rights. The data subject, they also have a right to lodge complaints with the ODPC. That is where now we are finding that the data subjects are being allowed to take complaints to the ODPC. Another one, I have a right to give you consent and to withdraw that consent at the same time. So in as much as I have given you consent to use my image, I have the right to withdraw consent for use of that information. Yes, those are some of the many rights that we have.
And in what ways can individuals redress if they believe their protection rights have been violated?
Okay, so first, we usually advise the data subjects to first try and resolve this matter by first maybe issuing a demand letter. For example, you have used my image on your website for marketing. I can send you a demand letter demanding you to pull down that image. So that is the first one. Another one, we can go to the Office of the Data Protection Commissioner. This is actually the office that has been given the mandate to protect us as data subjects. So that is the court that we actually take our complaints. Yes, another one that we usually use as advocates, we can use alternative dispute resolution mechanisms, whereby we can use mediation, we can use arbitration to at least come to a resolving conclusion.
All right, and is it unlawful for a security officer, manning the CCTV cameras? Of course, most of the institutions right now have CCTV cameras. Now, for example, if a man enters a lift with another man, and the security officer manning the CCTV cameras decides to, to record that clip and share it on social media, is it unlawful for the security officer to do that?
Okay, why are they sharing it to the social media first?
Because these persons are in the lift, maybe they're doing their things. Is it unlawful for the security officer, to record whatever is on the CCTV and share it on the social media?
Okay, so first things first, we go back to the origin of the lawful basis for having that CCTV. So the lawful basis for having CCTVs, we usually say it's called legitimate interest. Because in as much as I have my property, I have my own interests of safeguarding my property. That is why I will use a CCTV. So there, the entity had the right to use the CCTV. Now we go overboard and share that image to social media. It could be maybe we are trying to catch thieves, right? Yeah, that could be a legitimate interest, and it could also lie in the public interest, because we want to inform the public that there's this thief that we want to catch, and there's this crime that has been committed. Can you please help us to share? You've also seen people who are getting lost, like children who are getting lost, and their images are being posted, what they had won, and blah, blah. All their personal data is being posted all over the town. That is a public interest. And actually, you cannot sue me for posting your images because you were lost. I actually had a lawful basis.
All right. And in some cases, institutions have a book where you leave your data before you enter an institution. Maybe you leave your ID or your ID number and your contact number and your name. Is that data safe?
Okay, that is up to the entity to prove that the data they are collecting, they are actually safeguarding it, and they are actually applying technical and organizational measures to protect this data. And actually, the Act actually talks about protecting the data by design and by default. What we mean by design and by default is that in as much as I'm coming and leaving my ID there, you cannot leave it open like that. By default, you have to have a locked cabinet whereby you can keep that ID. That is by default. And then by design, for example, if I am sending information to an external email, that email can actually be flagged. Can actually be flagged as an email that is not supposed to receive this data. That is data protection by design. So when you're talking about leaving information there, it is up to the entity to ensure that they safeguard that data. And I can actually sue you for not safeguarding my personal data. And then when we're talking about the gates, every gate that has a security personnel collecting personal data, there has to be a privacy policy there at the gate, which is actually telling the people coming in, we are collecting your personal data for security measures, for security purposes. That is one of the requirements of the Data Protection Act.
And when the matter is in court, what fines or compensations have been imposed in cases, and what do the organizations handling personal data, or rather the fines and compensations, how do they look like?
They are huge. They are huge because now what the courts are considering, actually what the ODPC is considering, right now we have the rise of cyber, and we have the rise of cyber crimes, whereby we are finding people are using, for example, carding. People are using your personal data for fraudulent purposes. So the fines that are coming in, they are huge and huge and huge. An example I will give you is the Roma School, which is the Nothiru. So Roma School actually posted the images of the minors on social media for marketing. So when it comes to children's data, there are actually it is the Constitution which actually says that the best under Article 53(2), which actually says that a child's interests should be considered, the best interests of the child should be considered in every matter. So when this case went to court and they were using the minors' images for marketing, they were fined 4.5 million for just using the children's data on social media. Actually, you have seen the rise of TikTok, right?
Yeah.
You've seen the schools posting the children dancing, but they have to prove that they have parental consent for use of that image. You have also seen in entertainment establishments, whereby we are having photos being taken by the cameramen. And they are actually posting on Instagram and TikTok. That has become an issue. And we actually had a case whereby Casavera Lounge, it was fined 1.8 million for posting what do we call them? A customer's photo on Instagram without consent. So these fines are becoming huge and huge and huge. And we actually have another case whereby we have Mula Pride. Mula Pride was under KE Credit and Fair Cash. They are mobile lending facilities. Now Mula Pride was fined 2.95 million for just obtaining personal data of the data subjects from third parties without their consent. You're being called, hello, mimi ni wa Fair Cash, I want to advertise this product to you, blah blah blah. You have a right to actually object to that and ask them, where have you gotten my information from? Yes, and you can actually sue them for that.
And we often see that most cases in courts, you see cases from 3 years ago or something. How long do these data protection cases, how far is too far?
How long do they take
how long do they take
for the judgment to be? Okay, so now actually, because now we have the segregated office of the ODPC, it is actually faster. And actually it is not a must you go to court. we are filing these complaints online. We are having the judgments being rendered online. So you just get your judgment and you can go and execute the judgment against the entity that has been given. So when you're talking about the duration, we can give it 60 to 90 days. Actually 90 is too long, but they are actually taking the most minimal time they can to decide these cases, because we have had 10,000 complaints since 2019. We have had 10,000 complaints, and we have already had like 6,000 and something already decided, whereby we are having these fines and compensations being imposed. So you can see they actually have like 70% of their cases already decided. Yes.
And many people just click accept, in online platforms without reading the terms. Now, what does valid consent mean in Kenyan law?
Okay, when we say I agree and I accept, that has actually been termed as consent, because you are actually the user and you are actually the one clicking in. So it is up to you, it is your obligation to actually read those terms and conditions, because if something goes wrong, they will come to you and say, but you agreed, this is what we had said in our terms of use. So what we are encouraging the data subjects to do is to not be ignorant. Read those terms before you accept anything. Because now they have already complied with their obligation to inform you and obtain consent from you. So it is up to you as the data subject to actually read. If you don't have anyone to help you read, just ask someone to read for you, interpret for you, so that you can accept. But nowadays we only want to use and continue using the website faster. Yeah.
Actually, most of the people do not read the terms and conditions when they're sending into an application. Of course, that's a matter they should consider reading.
Yes.
Yeah. And from where you sit, is the ODPC adequately resourced, to monitor compliance across the country?
Yes, the office is. The office has actually been made independent first. They have their office, they have their website, they have their personnel, and actually they have their resources. When it comes to investigations, these people are doing thorough investigations. They're even coming to the establishments to do their own investigation. This is not like the other courts that we are used to. This ODPC office is actually, before they render a judgment, you can even go to the website, the ODPC website, and every case, it has the investigations, what the investigations said. So I can confidently say that the office is adequately resourced. And another activity that the ODPC partakes is audits. They actually come to, for example, the church. They can come to the school. They can come and do a full audit on your compliance. And if they find you're not compliant, they can give you recommendations. But if a complaint has come against you and they find that you are actually not compliant, now that will inform their judgment on giving you the applicable fines or compensations.
Right. Now, if someone's data is leaked, let's say, payroll, personal information, medical records, or photos, how can they seek redress?
Okay, the redress that they have now, you don't have to actually go to the High Court and start filing for constitutional petitions, no. Now what we have is the Office of the Data Protection Commissioner. You just file your complaint. They have a standard form whereby you file your complaint, you write the details, the full details, and actually when you have talked about payroll and medical data, that is sensitive personal data. So when you're talking about, you can even see right now the health institutions, when they are sending you your health reports, they are actually inputting the message on passwords. They're actually sending, if it's an email, you have to input a password. Because now this is a requirement under the Data Protection Act, that when you're sending these health records, that is sensitive personal data. Even payroll and even job applicants, when they are receiving these letters of offers and they have all the details of your salary expectations, your benefits, your pensions, and all that, that is sensitive personal data. And I can actually take you to court because, and especially if you have sent to a wrong email, that will land you in big trouble.
All right, and you know, for small businesses, churches, or schools that don't have, you know, lawyers, what is the simplest way to stay compliant with the law?
Okay, so first things first. Let's all have our privacy policies.
Yeah.
Do not go to ChatGPT and tell them to give you a privacy policy. Actually, just use a privacy policy that applies to what you're processing. For example, you can go to a privacy policy and copy and paste what an insurance company has. And actually, the personal data that they have in their privacy policy is not the same personal data that you are going to process, right? So what you're telling institutions is have your own privacy policy and do not just have it in paper. Issue it to the people that you're collecting the personal data from and ensure that these people have actually signed an acknowledge form that says, I have acknowledged the receipt of this privacy policy and I consent to the use of my data. Another one that I have already stated is consent forms. If you know you're going to collect, for example, images, you're going to collect sensitive personal data like health data, you have to collect this personal data. Even when you're processing children's data, it doesn't matter which data you're processing. When it comes to children, it is becoming a very sensitive matter, and you have to actually have these consent forms. So entities should make sure that they have their policies right, they have their privacy notices right, they have their procedures right. We don't actually want to have just a policy and we are not having a way of enforcing it and following it through. We have to have procedures. We have to have these documents, these consent forms. We have to have them in record. And we actually have to continue ensuring that data is protected by design and by default.
Right now, from that note, we say we want us to, to continue protecting our data. What are the very practical things that Kenyans should do to protect their personal data? Okay.
One thing, stop writing your passwords on your tables. Your company laptops, your personal laptops, stop using that. Another one that I've seen a lot of times when you're going to the airports and railway stations, we have an open Wi-Fi. And you're actually using your laptops and your devices that have financial information. They have a lot of your information and you're actually using that open Wi-Fi. Please avoid doing that. Another thing, avoid sharing too much on social media. Right now we have the social media, we have TikToks, we have streaming, we have YouTube. Avoid sharing too much. Why? Because when someone uses this information that you have given us online, you cannot sue them for using that information. Their defense will be, this information was actually in the public domain. So you cannot actually telling me that I have used your sensitive personal data and you are actually the perpetrator of your own crime, of misusing your own personal data. Those are the three I can tell people to continue using.
And looking ahead, what are some of the emerging trends or challenges in the data protection compliance in Kenya?
One emerging trend?
Yeah, or challenges.
An emerging trend I'll talk about is events, attending events. We are having these corporates and public entities organizing events. And actually when you go in the event, they actually have that privacy notice there that we are actually going to take photos. So by you entering the premises, you consent to us taking your personal data. That is becoming an issue because, as I've already told you, consent should be explicit. Like I have to sign somewhere. It doesn't, when you're talking about consent, it should not be implied. By me coming in here, I have consented. No, I have to have it in writing. So what we're telling entities is, do not be tired to print these consent forms. Print them and keep them in record and have people signing it. Another one is online marketing. We have this digital marketing.
Right.
Yes. So that is another emerging trend. We have Instagram, we have TikTok, we have Facebook, and people are actually, for example, I post my hair on my Instagram page, and my hairstylist takes my photo and posts it. Maybe for I can give you a practical example. We had Helen Modoni. She was a presenter at Inoro TV. So she posted her photo on Facebook, and then the hairstylist took that photo and posted it on their page. The hairstylist is a renowned stylist. So we have another company which is called Sisters. It is a braids company. So that company took that image of Helen, which she had posted on her own personal page, and posted it on its own page. So the purpose was established that Sisters was actually trying to market their product using a person's image. So when you're talking about marketing, it is a very controversial issue, and it is actually there on its own in the act. When you're talking about commercial use of personal data, we have to obtain consent. You have to allow the data subject to withdraw their consent. Once I have given you my consent to use my image, I can withdraw it at any time, and you have an obligation to pull it down when I have withdrawn my consent. Another one is you have to give me an option to opt out. For example, the messages I was telling you, send stop to *56. If a marketing message is coming to you and it doesn't have that opt-out mechanism, that's becoming an issue. That is an emerging trend. A challenge that is coming in is these data protection laws. They are requiring too much of the institutions. They are requiring us to input policies. You know, it is not an easy thing to have these policies on our website, to have actually systems that are able to ensure that the data is accurate. That is also a requirement in the Act, that you should have data being accurate. We don't have these entities, they don't have systems and mechanisms and resources to ensure that they are actually keeping this data private.
All right, even as we wind up, we often see in courts cases involving minors where you see, the people attending the court proceedings are told to, to move out so that the minor can be left with the judge and some other people there. So why is that?
As I've already reiterated before, we have Article 53 of the Constitution of Kenya. And as I told you, the Constitution of Kenya is actually the queen mother of all laws in Kenya. So when you're talking about a child under Article 53(2), it actually says that the best interests of a child should be considered in all matters. Then when we are coming to the Data Protection Act, they are actually considering children as a very sensitive topic in the society. So you can even see the judgments that are being given. They are actually, maybe a child is Erica Minor Kangede, they are writing it EMK because they don't want to disclose the name of this child. A child is a very sensitive matter in our country. That is why we have the right, we have the, not actually the right, we have the obligation to ensure that they are protected from anyone, from the public, from the world. They have the right to be protected. All right.
Now, even as we wind up, tell us about, someone wants you to represent them in courts, maybe matters data protection rights, and where can they reach you out?
Okay, so as I've already said before, my name is Maureen Gaki Kubai, and I am an advocate of the High Court of Kenya, practicing in data protection compliance. So I am based in Westlands, and I am under Mutie Advocates. You can go to the website and look for Mutie Advocates. It is there, and we are based in Westlands at ASI Center. And I have my socials. You can check me on LinkedIn, where you can get my contact and you can message me as Maureen Kubai.
All right, thank you, Maureen Kubai, for making time to be with us here this morning.
Thank you for the invite.
All right, it is exactly 2 minutes past the top of the hour. Many thanks for, of course, keeping us company until this particular minute. I believe that you are now educated, rather you've got insight matters to do with data protection laws in our country, Kenya. Right, it is exactly 2 minutes past the top of the hour. My name is Martin Masharia. Many thanks for, of course, being with us, rather making time to be with us this particular morning. Your Faith Today is coming up next in the top of the hour at 9 a.m. You don't want to miss that particular show. Let's meet again later on in the day, even as we continue to keep you up to speed, those making headlines from across our 47 counties, and of course across our borders as far as news is concerned. But until then, let's do this again when God says we do.